Meanwhile, welcome to week 3 of our training. This week we will be dealing with interpretation of legislation. Interpretation of legislation. We have dealt with in week 1 we have dealt with the history introduction to legislative drafting. We looked at the history from 1869 till date. We looked at legislative drafting as a distinct area of law. We looked at career prospects in legislative drafting. Then last week we examined ICT and legislative drafting, looking at application of ICT to legal research and drafting, technological innovations in legislative drafting. We also considered modern approaches to legislative drafting. And within the week, last week, we had a guest lecturer from Brazil, Mr. Luis, who gave us a detailed lecture on what they have been doing and how we can harness technological innovation to improve our drafting and legislative business generally. So this week, we are entering interpretation of legislation. We'll be looking at plain language, gender-neutral drafting, and the other aspects of legislative drafting. That's basically what we'll be dealing with this week. Plain language, gender-neutral legislative drafting, and other aspects of legislative drafting. So, as usual, fasten your seatbelts. An assignment was given last weekend. Please, how many of us have done and submitted the assignment? It was a very simple assignment. Has anyone here attempted the assignment? Senate, have you done your assignment? Hello, Senate. Tebo, have you done your assignment?
Yes, sir, I did my assignment.
I submitted to Prof.
Yes,
awesome.
I did.
Welcome. That's great. Libe, good afternoon and welcome. Hello, Libe, good afternoon and welcome. Have you done your assignments? Mr. Solomon.
Yes, good afternoon.
You joined us late last week. Were you able to try your hands on the assignment?
Yes, sir.
So you exempted us from doing the assignment.
How? Oh, did I express?
You said you joined late, so we have to take review. You said you take a review of the class.
Okay, yes, I remember.
Yes, sir.
I said yes,
Yes, sir.
you still yes. I remember that.
Yes.
I remember.
Yes, sir.
Good and welcome.
Thank you, sir. Good afternoon, sir.
Good afternoon. Where are your other colleagues? It's only you and Mr. Solomon that are here for now.
Some of them are still in court, sir.
Okay. Koena, good afternoon. Koena Matladi, good afternoon. Can you hear me, Koena? Narasha Legal, good afternoon and welcome.
Good afternoon and thank you.
Have you done your assignment? You joined us almost towards the end of life.
So I haven't had time to go over the material that was shared so that I could understand the assignment.
It's understandable.
Thank you.
Prof, good afternoon, ma. Glad to know you are finally able to join. Welcome, ma.
Thank you.
Okay, ladies and gentlemen, our time from my end is 10 minutes past 2. I will go straight into today's lecture. I am scrolling through to see if there is a first timer. I am seeing one E. Monjok Agom. Agom. Mr. Agom, good afternoon. Or Mrs., but I guess it's a Mr. Agom, good afternoon. Can you hear me? Monjok? Hello, E. Monjok. I hope I got the name correctly. Good afternoon. If you can hear me, Mr. Agom, kindly respond by yourself. Okay, he has exited the call. I think I have another person. Abby George, good afternoon, Abby.
All right. Good afternoon, everyone. My name is Abigail Tam George. I hope that suffices.
Not only we want some more like Oliver Twist. Where are you joining us from? How did you get to hear about the platform? Are you into private practice, government employment? And finally, okay, not finally, have you had any background in legislative drafting? And finally now, your expectations from this class.
That's quite a
Quite a few.
literature legislative drafting request. All right. So I practice here in Lagos. I'm in Lagos.
But your name gave you away as you coming
Private
from Niger
practice.
Delta area.
Yes, I'm from River State.
Awesome.
I am based and practice in Lagos State. What else? I'm into private practice. I do not have any distinct
Prior knowledge.
experience in drafting. But I mean, as lawyers, I think we're quite conversant with what happens in that area.
Really?
Yes, we do. I mean, that's our work. That's our daily bread.
Legislative drafting.
That's our daily bread. Every day we
Legislative
try to.
drafting.
Yes. That's what I think. So the nuances and all of that.
I'm expressing surprise. Yes, I am. But you will get to know, or rather, you will get to know as the class progresses. It's unfortunate you missed our first week, but it's fine. You are here on the week. We will always make reference to our history.
Thank you.
Yes.
Yeah. So my expectations, perhaps to straighten out some of the areas about legislative drafting, give it a bit of focus, and learn more out of this class, really. Thank you.
Awesome. You are most welcome, and I want to assure you that you are in for a big surprise, particularly because you thought that legislative drafting is what we do as lawyers and we are all conversant with it. I get your point. Probably you mistook legislative drafting for legal drafting. If you are saying legal drafting, yes, that's what we do as lawyers. But legislative drafting is a distinct area, law practice, and with time you will get to know. Thank you very much. Madam Joyce, welcome. Good afternoon. I have been expecting you before now. You are usually an early caller, so I wouldn't know why you hopped in late. However, it's good you're here. Welcome. Okay, without wasting time, I'll be handing the class over to our coordinator, the Executive Secretary of ALDRAP, in the person of Professor Tonye Clinton Jaja, to kickstart today's class. Thank you. Prof, over to you, sir. Prof, sir.
Yes.
Thank you.
How many of you can swim? By show of hands, just click on your, if you are a good swimmer, just click, raise your hand. Let me see. Okay. Now, good. Okay. Very few of us are swimmers. Now, the question, if you want to teach someone swimming, how do you do it? Do you teach them from your house? How do you go about teaching swimming to people? Yes, I'll pick on those that have raised their hands as swimmers. Teboho, please tell us, how will you teach someone swimming?
Yes, Prof. I'm not a good swimmer myself, and I don't think I was taught swimming in a rather formal setting. It was rather in a formal setting when I was a boy growing up. We used to do it in the rivers and the dams. So, in terms of teaching somebody, I can't really say how I can go about that one. But
okay, good. Someone else who has taught someone to swim. Solomon, have you taught anybody, your children or anybody, how to swim?
I've not taught anybody, but I've been taught how to swim. And one of the things that the person who taught me how to swim did, I've learned it in an informal way, but I've had cause to meet coaches who guided me on swimming. One of the things that the first thing he had to help me to demystify whatever phobia I have about the waters. He explained what the swimming pool is all about, the depths, the various depths in the swimming pool, and the things to avoid. And after doing that, he took me to the swimming pool where I saw people, and he started with me from the lower depths. Then he started with tube, putting me inside the tube, and then gradually he started teaching me how to flip the legs, and then how to navigate on the water depending on the style I want to adopt in doing the swimming.
All right.
Then he taught me how to catch my breath too.
Thank you, Solomon. In the chat box, if you can read, Madam Shetak has said, I am not a swimmer, but I will think you will take the person to the pool. That's the answer I needed. I will share with you my experience. I come from River State, so we have rivers all around. But I grew up in the city. The capital of River State is Port Harcourt. I was born there, I grew up there. So, but on Christmas holidays, my parents would take us to the village where we have rivers. And because I've been watching a lot of TV, I see people doing like this when they are swimming. So I thought I'd learned swimming by watching the TV weekend. So when we went home one holiday, I saw teenage boys, how they jump in, they do like this. I said, well, I have learned swimming. I've been watching it every week on the TV. So I went into the river and I started doing like this. That was the last thing I remember. I was doing like this. I was drowned. I had already fainted. They had to press the water out of my tummy, nose, everywhere, before I recovered myself. So the lesson is, you cannot learn swimming by watching TV. Oh, this is how they do it. And just wake up one day and you say you want to do it. No. You have to practice. Go to the pool. Learn how it's done. You stay in the shallow part. So after that experience, when we came back to town, I went and registered at the swimming pool, Port Harcourt Club. Every weekend, they now show you how you swim. You start with the shallow parts, and then how you float, as Solomon was saying, how you hold your breath underwater. So the lesson is, you have to practice to get good at it. And you practice inside the pool. You don't stay in your house and watch TV and say you are practicing. or even in the bathtub. So when it comes to legislative drafting, you can only learn drafting by drafting. So there's no, you cannot learn drafting by talking. Drafting is not like litigation where you go to court and do your advocacy. Drafting is only by you write, you draft. So when we gave the assignments, I was happy a lot of you could see that by writing, whenever you write something, it becomes part of you. So I will encourage you in the course of this course, we'll be giving assignments. Take time and do it. Because as you write, as you draft, you become better. But if you do not practice it, you only attend this course. Yes, you have attended the course. But when they give you something to draft, a piece of legislation, a bill, you cannot deliver anything. So that's my encouragement to you. Please practice. The more you practice, the better. When I was training for LLM in legislative drafting, my lecturers used to give me, they will go and get briefs on legislative drafting. They are in dollars, but they will use us, the students, for free work. We draft it for them. They weren't paying us because they were our lecturers. So we do it for free for them, and they go collect the money from UNDP. But my project supervisor, he was so clever. He was a UNDP or UN assignment. He now to me as a project topic. My LLM dissertation was he was told to do. He was paid, not even told. He was paid by UN to do the work. I only found out later. I was busy doing the LLM dissertation, not knowing that my supervisor was using it to earn his money. So the more you draft, the better you become. That's the lesson, the moral of the lesson today. So today we are doing a very important part of legislative drafting. Is related. It's called, in fact, if you're doing our LLM course, there's a course called Interpretation of Statutes, Statutory Interpretation, because there's a link between how laws are interpreted and how laws are drafted. The two must synchronize. So it is very important that you understand the principles of interpretation of legislation. And because once you understand the principles of interpretation of legislation, then you can also understand why they are written the way they are written. So the two go hand in hand. So it's important for you, this topic, interpretation of statutes, interpretation of legislation. Please pay attention. One of the most important moments in my life was when I was invited by the Supreme Court of Nigeria to help them with the interpretation of the Code of Conduct legislation in Nigeria. It's a 1991 legislation. The Supreme Court invited me, what they call amicus curiae, to write. The Justice of the Supreme Court, who is now late, Justice C.C. Moise. He was my lecturer at some point during my NYSC. There was a very political case, very controversial case. Now, the law they were trying to interpret, the Supreme Court was trying to interpret, they needed an expert in legislative drafting to tell them, why is this law drafted like this? So that was to show you the importance of the relationship between legislative drafting and interpretation of statutes. They all go hand in hand. If you know how a law is written, then you would know how it will be interpreted. Because there are rules that govern interpretation of legislation, there are also rules that govern the writing, the drafting of legislation. So immediately, you may not know what this means, but as we go along in the lecture, you would understand. In the common law jurisdiction, we have three major rules of interpretation of legislation. Later in this lecture, we'll also look at the rules for interpretation of the Constitution. The Constitution is a legislation. However, the Constitution is a different kind of legislation. It is higher than all other legislation. Remember Section 1, Sub 1, Sub 3 of our Constitution. The Constitution is the most superior law in any country. If there's any conflict between the Constitution and any other law, the Constitution will prevail. So the rules for interpreting the Constitution are different from the general rules of interpreting other legislation. We'll explain this later. So let's start with on your chat box, you will see the three rules of interpretation of the Constitution. I'll start with the first one, literal. Literal rule means whatever you see, black and white, that is what the courts will give meaning to. The black letter law, we call it the black letter law. So anything which is only what is there in black and white that the courts will give meaning to. The literal rule of interpretation means that it is only what the courts see in black and white that the courts will give meaning to. It's a very important rule of legislative drafting. So, of interpretation of statutes. Now, because of that rule, we now have a complementary rule in legislative drafting called the mongoose principle. The mongoose principle, I put it on your chat box, is the principle that says when in doubt, when you're drafting, if you're in doubt, it is better to err on the side of surplus. That means you draft more to explain, to make it clearer. In legislative drafting, the rule of drafting is we err on the side of surplus because of this literal rule of interpretation. Literal rule means the courts will only give meaning to what they see in black and white in the legislation. They will not, no court of law would imply what is not there in black and white. That's why the judges will always tell you, my hands are tied. Anything that is not written in black and white, the judge is not at liberty to add. This is because of the literal rule of interpretation. And this is related to legislative drafting because we have what we call the mongoose principle, which means you err on the side of surplus. You draft more, clarify, to explain, so that there is no doubt in the minds of the reader or the user of that legislation. So the mongoose principle, what is the mongoose principle? So I'll call on Ebenezer to explain the mongoose principle. Ebenezer, please.
Okay, thank you, Prof. The mongoose principle is a principle of legislative drafting that allows you to err on the side of surplusage. This is of words, the principle against verbosity. We talked about tracing our history. We said the early drafters were drafting because they were paid per word. They were drafting, repeating words, and their drafts were voluminous so that they could make more money. And we are now saying, no, your draft should be straight to the point. However, the mongoose principle is an exception to that rule, in that the principle states where there is need for clarity, you can draft more to achieve that clarity. So you see the difference. You are not drafting more because you have enough ink in your pen. You are not drafting more because you have a reservoir of vocabularies, but you are drafting more to explain, to achieve clarity. How did this principle come about? You know this animal that is called mongoose. Here, it operates at night. It doesn't see in the daytime. The ones we have here, I don't know whether you have an equivalent of that animal. It wants to look like grass cutter. It's within the rat family, but it's bigger than the domestic rats. It does not see in the daytime, but it sees at night. Now, since it's in Australia, the animal, they don't kill it. They even have it as pets. So it is more like a free range. It associates with human beings. They sell it in the market and people keep them as pets. Now, a woman sent her housemaid to get, or houseboy to get her mongoose, to buy that animal. But she did not know the plural form of that. Is it mongooses or mongoose? Because she wanted two. So she has written on paper, she didn't know whether to write, buy me two mongooses or buy me two mongoose. So she wrote, buy one mongoose, buy another mongoose, so that she does not make spelling mistake one, and also does not lose clarity or confuse the message sending. So that's where that principle was derived from, that against the principle of economy of words, you can draft more for one reason, to achieve clarity. Thank you, Prof.
Thank you. So you have seen the relationship, the link between the literal rule of interpretation of statutes and a drafting principle. Because of this literal rule of interpretation of statutes of legislation, we now have the mongoose principle, which says you need to draft more so that the meaning, the intended meaning, is clear for anybody, especially the judge. So you can see the relationship between the interpretation of statutes, literal rule, and then the other is the mongoose principle. So this is the relationship. On our charts, we've posted these materials. It's found in page 61 and 62 of, there's a book by Ian McLeod, 2009 book, Legislative Drafting. So the second rule of interpretation of statutes is called the mischief rule. What is the mischief rule? All of us who did law, we must know it. Can somebody explain the mischief rule? Raise your hand. It's an interactive session. What is the mischief rule in legislative drafting? Okay, we have, let's see. Please, let's see. Can you answer?
Okay, thank you, Prof. The mischief rule inquires into what was the mischief intended to be covered by the legislation.
Okay, so how does it apply when judges are interpreting a legislation, a piece of legislation?
The judges would look at what was the law before or what were the circumstances before the legislation sought to be interpreted, and then they would look into what was then the purpose of the legislation subject of interpretation in order to establish what was the initial purpose of the legislation in addressing the mischief which is at hand in a given set of facts.
Okay, thank you for that attempt. Those of you who were here from the beginning, I say if you want to be a good teacher, even as a good lawyer in court, you should explain something in a manner that a 6-year-old child can understand it. So you don't use many words and confuse us. What is the mischief rule? In simple terms, what is the mischief rule? You have said so much. People may not even understand what you're saying. You're speaking as if you're speaking to professors. What is the mischief rule? Explain it to a 6-year-old child. Yes, anybody? Anybody? What is the mischief rule? Because these are the rules we use.
Let me try, sir.
All right. Madam Nkiru, go ahead.
Hi, the line is breaking.
Go ahead. We are listening to you.
Madam Nkiru, we can hear you. Go ahead.
Okay, sir. My line is breaking, but to give it a try.
Yes.
Okay, so is an interpretation that seeks to find out what the problem is in a statute. That's the scope of the statute, identifying what the problem is and solving it. The mischief in the statute, the scope of a legislation, so that the problem can be solved.
Thank you. Narasha, please.
Thank you. Mischief rule is presupposes that you need to look at the intention of the legislature in drafting the legislation. If the provision is ambiguous or not very clear, we look at the intention behind the legislation in order to interpret what could have been meant. Thank you.
You guys are just confusing us the more. Can somebody explain the mischief rule in a manner that a 6-year-old child would understand? Yes, Teboho.
Yes, Prof. I think judges will try to find out what was the problem that the legislation was intended to solve.
Simple. Simple. Mischief. What was the mischief that this law seeks to solve? That's the meaning of the mischief rule. There was a problem. Then this law came to solve that problem. So the judges would ask themselves, what was that problem that this law sought to solve in the first place? And then they will interpret, give a meaning to that law to avoid that problem. That's the meaning of the mischief rule. To draft a law to solve a problem. Then the way you draft is to solve that problem, not to create problems. So imagine those of you in Lesotho, let's assume there's a problem that young men are no longer attending schools because of initiation schools. Those of you from Lesotho, you know what I'm talking about. Now, if the government calls you to draft a law to solve this problem of initiation schools clashing with formal school, so the mischief is that initiation schools are preventing young men from attending regular secular schools. So you have to, initiation schools should only happen during holiday period, when the regular secular schools are on vacation. So the mischief, what is the mischief? Now, in 1993, there was a turning point in all Commonwealth jurisdiction. The name of that case is Pepe versus Hart. Hart is spelled H-A-R-T, 1993. You can Google this and read it. I've put it on our chat box. 1993. It's a 1993 Supreme Court of UK case, but we all apply it because we inherited our legal system from the United Kingdom. Now, in 1993, the Supreme Court held that before 1993, judges were not allowed to look at the Hansard. Hansard is a verbatim report of the debates that go on the floor of the parliament. Any parliament have what they call Hansard. It's a document where all the debates, the word for word debate is there. Now, if you want to find out the intention of Parliament, what was the thinking of Parliament when they were passing any law? From 1993, you have to refer to the Hansard. The Hansard is the verbatim report of all the debates that happen on the floor of the Parliament. So from the year 1993, whenever the wordings of any law, any legislation is ambiguous, you have to refer to the Hansard. Hansard is where you see word for word what were the members of Parliament debating, what they were saying. You see it word for word. So that's the mischief rule. If you want to know the mischief, what was the mischief that the Parliament was intending to solve, you go to the Hansard. Hansard is a verbatim report of the debates. The day that law was passed, the debates, you will see it there. So that's about the mischief rule. Now, you draft in a way to overcome that mischief. As a drafter, if you are instructed to draft a law, a legislation, so what was the problem the government wanted to solve? You draft in such a way that that problem is solved by your legislation. Now, there's another rule of interpretation called the golden rule. The golden rule means that whenever there's a legislation in dispute, the judge will interpret that legislation in such a way that it is not absurd. If you give the literal meaning, would create absurdity, then the judges would interpret it using the golden rule. The golden rule means you interpret the legislation in such a way that there is no absurdity. It doesn't result in absurd meaning. For example, if a legislation mentions only man or masculine gender, if you take that legislation to court, the judge will not interpret it in such a manner that it will lead to an absurdity. For example, to say that the parliament shall only be, members of parliament shall only be male because the law says he makes reference to he, masculine gender. The judges cannot interpret the law, even though the law says he. That literal meaning, if you say only he, that means only men will be members of the parliament. But that cannot. So the judges would interpret the law in such a manner that it does not result in absurdity. So they will look for the intention of the parliament, and the document to look for is the Hansard. They can look at the Hansard and get the intention of the drafters or the parliament. So these are the three rules of interpretation, and they affect the way we draft legislation. Now we have other rules that apply to constitution. Constitution is a different law. It's the highest law in any country. It's called the grand norm. Now the rules that apply to the constitution, there are 12 rules. If you look at your charts, you will see them. I cannot repeat them there. In Nigeria, those 12 rules of interpreting the constitution were brought out in the case of Attorney General of Bendel State versus Attorney General of the Federation, 1981. There are other cases too by Attorney General Bendel and Attorney General Federation. But the one of 1981 is the 12 rules, the canons of interpreting the Constitution. We have another rule which we call the blue pencil rule. The blue pencil rule, when you're interpreting the Constitution, means when some sections of any law are in conflict with the Constitution, those sections of that law, a blue pencil will be used to cancel those sections. That's the blue. Those sections of any law that are in conflict with the Constitution will be deemed null and void. They will be deemed unconstitutional. Therefore, they will not apply. That is called the blue pencil rule. So if section 2 and 5 are the portions, the provisions that infringe on the Constitution, sections 2 and 5 will be deleted using the blue pencil. That's the blue pencil rule. We have the red pencil rule. The red pencil is when a legislation in its entirety is in conflict with the Constitution, a red pencil will be used to cross out the entire legislation. So that is the red pencil rule. The blue pencil means you're not crossing out the entire legislation, just the portions of the legislation that are in conflict with the Constitution. Those are the portions that will be deleted. So what does this tell you about legislative drafting? When you are drafting any law, you must make sure that the provisions of that law are in harmony with the provisions of the Constitution. That's a task for a legislative drafter. It means that when you finish drafting your bill, you have to start from section 1 to the end to make sure that no section conflicts with the Constitution. So this is the relationship between interpretation of Constitution or legislation and legislative drafting. So it's very important you have this knowledge when you are drafting. Questions? Any questions? We have 10 minutes for questions. Yes, Solomon. Unmute your mic and ask your question.
Okay, yes, sir. Thank you so much for this far we have gone. I'm trying to ask the spelling of the. You say you will locate the intention of the legislature from the. You are calling a name. I'm trying to get the spelling. I'm not getting it.
All right. Check the
answer.
Check your chat box. You will see the spelling.
Okay. I've seen it, sir.
Any other questions? If we're logged out, that will be the end of class for today. Any other questions? Questions? You can unmute your mic and ask. Any questions?
Hello, Solomon. We can't hear you. Was that your only question? It seems you still have some questions. Go ahead.
Yes, sir. Now, I'm trying to wonder now for a judge that that encounters a situation where he needs to interpret it. Does he also need to go to check the intention of the legislature in the Hansard before he can arrive at a decision, or is the person who is seeking to have the interpretation that will now make the intention of the legislature available? Because what I notice is that what the judge has at hand is only the law. So how does he go to find the intention of the legislature?
All right. So the principle in Pepper versus Hart, 1993, there's a caveat. It only applies when the wordings of any law are ambiguous. I repeat, when the wordings of any law are ambiguous. Take your time and read Pepper versus Hart, 1993. It's online, it's available. Yes. Koana, please ask your question before we get logged out.
Thank you. I wanted to know you mentioned the importance of knowing whether your law is in contradiction with your supreme law, that is the Constitution. What about harmonizing the legislation that you are trying to draft with international instruments? I'm talking about your CAT, your CEDAW, etc.
So the caveat is, so long as international law has been made domestic law, in our country there's section 12. Even though you go and ratify international treaty, the National Assembly of Nigeria needs to pass it as a domestic law. If you have not passed it as a domestic law, then it is not part of your corpus juris. It is not part of the laws of your country. So, yes, when you're drafting, you also you make sure the bill you are drafting is in harmony with the 552 laws of Nigeria. So it means you have to go and look at each of the laws of Nigeria to make sure it is in harmony with your bill is in harmony with the existing laws. The only international laws that you will have to comply with are those international laws that have been domesticated by your National Assembly. Yes, somebody mentioned the objects. In Lesotho, they call them the objects. And there's a statement of objects in laws. In Commonwealth, the general rule is that we do not write statement of purpose, objects of laws. The reason is because it is purposive approach to interpretation, which is done by only civil law jurisdictions such as France. They have what they call purpose clause in their laws. Every law has a portion where they call the purpose clause. And that is because their judges use that for interpretation. Our judges do not read meaning into the purpose or objects of our laws. So this is a clear distinction you have to bear in mind. We'll come back to it when we start doing preliminary provisions. Very important. The drafters of Lesotho laws may have copied that without knowing. That's why they have statement of objects in their laws. They didn't know that this is a civil law tradition from France and other European countries. We'll talk more about it. So whoever is doing it, I've kept saying this, even in Nigeria, some people copy statement of purpose, statement of objectives in a law. It is not a common law tradition. It is because our rules of interpretation are not purposive. Go and Google online, you will see purposive approach to interpretation. It means looking at the purpose to interpret a law. The purpose clause. There's always a purpose clause in France, which is a civil law jurisdiction. We are common law jurisdictions. We do not use purpose clause or purposive style of interpretation. Remind me when we're doing preliminary provisions, we'll talk about this. Any other questions?
I was responding to Shetak and Solomon on the chat. I hope you heard what Prof said. Solomon. Okay, they have responded. Thank you. Okay, ladies and gentlemen, in the absence of any other question, we will be bringing today's lecture to a close. However, before we do that, I cited a name that I wasn't too familiar with. He has left the call. Okay. The person has left the call. I was waiting for the end of the class so that I can get the person to do the needful by introducing his or herself. Okay, thank you very much. We'll meet again tomorrow, same time. I believe by this time we already know that our Nigerian time is 12 noon and the Lesotho time is 1 p.m. Thank you, goodbye, and have a stress-free day.
Thank you so much, Mother.
Thank you so much, sir. Bye-bye.
Thank you, sir.
Right,
Bye.
thank you very
Thank you,
much.
sir.
Thank you, sir.
Thank you very much, sir.